Thank you for joining us for another edition of Work Comp Matters videos. This episode is with applicant attorney Michael Burgis, and we're talking about trial technique, how to get yourself a successful findings and award from start until finish. Mike, take it away.
All right, kind of a broad topic here. I'll just talk about little things that pop in my head here. First off, somebody gave me a bit of advice early in my career, and I really took it to heart, and it's paid huge dividends for me. And they said, Mike, try everything. If you don't get what you think is just for your client, just take the case to trial. I would advise all the listeners here to really, you should gear every case up for trial as if you were going to trial regardless.
I could not agree more. I never take a case without preparing to go to trial. Yes, my preference is to settle for a reasonable amount, but if I can't get in that range, I am prepping that case for trial.
Of course, and you know, defense attorneys aren't dumb. They know who goes to trial, who doesn't.
That's right.
And not only that, they can tell a case that's being prepared for trial, what's substantial medical evidence, what's not, what holes are in there. And listen, you show up to court and you're not prepared, or you show up to trial and you don't have exhibits tabbed, ready to go, the defense attorney smells blood in the water. So you always have to gear your cases up for trial. You always have to be prepared to try the case. And I will tell you that if you gear your case up for trial, 99% of those cases are going to settle the day of trial, if not before.
Well, isn't it true that 90% of all cases, regardless of the type of action, settle, and then those that go to trial, 90% of those settle on the day of trial?
Those are probably pretty close accurates. I think I'm a little bit more litigious, so I tend to go to trial a little bit more than the average
You
statistic.
do have a reputation for trying more cases than the average workers' compensation attorney.
Which is why my clients get more money than other.
I'm not saying it's a derogatory thing. A fact is a fact.
Yeah, I'm just of the opinion that like I said, I'm a big statistics nerd. I look at what the offer is. I look at what my F&A. Here's the other thing. I envision what the F&A is going to look and what the basis the judge is going to do to issue the F&A, and then I frame the case in a way that makes it easy for the judge to award it and issue that F&A. So water flows through the path of least resistance, right?
Correct.
And judges, like anybody, have a lot. They want to do.
They don't want to try cases.
Yes, I'm trying to think of a politically correct way to say this is.
No, a judge. Why would a judge want to try a case if he's got to take the time to do it? Then he's got to take the time to issue the summary of evidence. Then he has to write the opinion. Then he has to worry about an appeal, and he has to answer the appeal.
Of course.
I mean, part of a judge's job is twisting arms a little bit to convince the parties to settle. That's part of a judge's job.
I don't disagree with that, and I don't actively seek to try cases because I don't get paid by the hour. I don't want to be caught.
I would much rather settle.
So of course, but I gear all my cases up for trial. And when I say water flows to the path of least resistance, what I mean by that is the judge knows who's prepared. The judge knows who's good. The judge knows who, if they don't find in favor for them, is likely to recon with success versus who's likely a soft target. And I will tell you that if you're prepared and you gear your case up for trial and you show up at trial with your exhibits, nobody should wing it in trial. Even me, who I've done lots of trials, I still have a full outline.
Michael, you've mentioned about 3 times now about being prepared, and I couldn't agree more. I was taught a long time ago that it's more important to know what is and what is not in your file than knowing the law. That's part of being prepared. And number 2, my father, a 30-year applicant workers' comp attorney, always told me about the 3 B's. Begin, be brief, and be seated. I'm referring to questioning witnesses now.
I love that. I remember that the judges are busy and they don't want to hear you conducting a deposition, especially with irrelevant questions. What I do is I look at my steps and issues. I say, what are my issues? What do I want the F&A to say? What evidence do I need to provide the judge via medical evidence or testimony? And then I'm very quick. I'm very methodical.
I am very quick also.
You ask the questions, you get in, you get out. And then, the burden will shift to defense to try to unravel some of that stuff. And then, you do what you need to on cross. But I'm very methodical. I get in, I get out. I come prepared. Trial briefs, by the way, I'm a big proponent of trial briefs. Even though it's a lot of work, there are certain things that you need to argue and bring to the attention of the judge. And you can't effectively do that via medicals or testimony. And sometimes you really do need to do a trial brief. And I'll also say, when you show up with a very well-written trial brief, that is also a strong indication to the judge that can easily be converted to a petition for reconsideration. But I don't mean that in a threatening sense, but it helps with, if you're providing the judge the authority, it makes it easier for him to find for you. So you are becoming the path of, you are not the path of least resistance. And then the judge sees very quickly, like, hey, you're helping him formulate the F&A, and you put in the time and effort. So some people ask, I have a very successful trial rate, a very successful appellate rate, and I'm batting 1,000 on writs, and I've taken a significant amount of these both on both sides, and I've won every single one, partly because my wife is such a brilliant writer as well. But it's because I put in the time and worked my ass off. Because I don't care how good you are, how many trials you do, you still need to know the law. You can
never be prepared enough. Last thing. Sometimes I take a lot of time preparing a witness, and other times I hardly take any because I want that spur of the moment thought. Last question. How much time do you spend preparing your witnesses?
It's a good question. One, as most applicant attorneys, it's usually a high volume practice. We're only making 15%. If you spent significant time prepping your witnesses, it's going to be a hard business model to be profitable and deal with your other cases. But the answer to that question is it depends. It depends on the client.
It depends on the facts of the case and the client. And I'm going to ask you one other question. 776, when you call one of the defense witnesses on adverse witness, how often do you do that, and why do you do that? And then we got to close it out.
I do it. It's I love when I hear people that do that. I do it when...
My father always said the only time he would call on 776 is when he knew what the witness was going to say, because the golden rule is you never ask a question that you don't know what the answer is going to be.
I do it when I know what the answer is going to be, and I know the defendant hasn't had the opportunity to prep their witness, and they're there.
How do you know that the defendant has not prepped their witness?
You don't, but it's an educated guess.
A gut feeling.
Yeah, and generally, you can see attorneys who are prepared or not.
Absolutely.
But when I think there's something that's important to get out before they've been adequately prepped, I do it. But the truth is, the vast majority of these cases, you don't need to do that, because as long as your client is credible and credibly testifies, look, all the cards are stacked in our favor. You got Labor Code 3202.
We only need 1% unless it's a site claim.
Yeah, but that's a clever thing, and I have used it. And I'll tell you, there are times that I've strategically withheld putting evidence in my case in chief because I knew the defense was going to lie, and I wanted to get it in on rebuttal. Exactly. Like, for instance, homeowner. I do a lot of UEF trials, and I have homeowner policy investigations that I don't list, and then I let them lie on the stand, and I was like, well, really, that's not what you said during the insurance investigation. You can throw that out. So there are some clever things you can do, and a little bit of gamesmanship, and all has its time and place. But for the most part, you just be prepared. I try not to represent clients that I don't 100% believe. So the truth is, I'm always pretty confident in trial because I'm representing a legitimate, injured worker. And if I smell any BS, I usually get rid of that case quick, and I'm not at trial in that case.
What a great way to end the segment on trial technique. My expert attorney, Michael Burgis. My name is Steve Appel. You've been listening to WorkComp videos, and we will see you during the next show.